This is the second open meeting of the Committee on Members' Interest. It's the appointed time, and we have a quorum. I call the meeting to order. Item number 1, confirmation of minutes. This is paper number CMI/25/12 to 13. This minute has been circulated given to members. Any proposals for amendment? So far, the clerk has not received any proposals for amendment. If you have no proposals for amendment, then minutes confirmed. Next, review of the procedure for handling complaints in relation to the registration or declaration of members' interest or members' claims for reimbursement of operating expenses. If you refer to the minute of the last meeting, you see that members have shown great concern on this issue. In the last meeting, members agreed to review the procedure for handling complaints in relation to members. And a letter has been sent to all members on the 27th of January. This is paper CMI/26/12 to 13. We can have a further discussion in relation to this paper. A number of issues has been pointed out by the CMI of the 4th Legislative Council. They have made a number of proposals to the changes of the relevant procedure. If you refer to paper number 26, we have a number of issues to deal with. Page 2. Sets out a number of issues that needs our further deliberation. First, time limits under the procedure. I'll ask the clerk to give you a briefing of the number of points for further discussion proposed by the CMI of the 4th term. Thank you. In relation to time limit, it's referring to the procedure of a decision to whether to call a meeting. First, the chairman is to decide whether a meeting will be held. If so, within 7 working days, the meeting will have to be convened. If within 2 working days the chairman decides not to call the meeting, members will be informed, and members may overturn the chairman's decision of not holding a meeting. If the majority of members are of the view that a meeting should be held, 7 working days, within the 7 working days after a decision of the majority of members is made, a meeting is to be held. 5 complaints has been handled by the last CMI relating to 12 members. The experience is that within 2 days, the chairman will have to be contacted for the chairman to decide whether the meeting should be called. It is rather limited. And then the chairman will have to, within 7 working days, find a schedule for members to convene to have a meeting, especially towards the end of every legislative term. Members tend to be rather difficult. We need 3 to form a quorum, and there are only 7 members. But when it comes to handling a complaint, it would be better for more members to be present. And if towards the end of a legislative term, the chance to find a day that is acceptable to a large number of members to hold the meeting within 7 working days is difficult. And last time, there were discussions as to whether to extend the decision to hold a meeting from 2 working days to 3 working days, and then for the first meeting to be held within 7 working days to be extended to 10 working days. Well, if a complaint is received within 2 working days, the chairman will decide whether to call a meeting, and then a meeting may be called or not. And then the secretariat will inform members. But I may not receive that on the same day. What about the time limit? If I think that, well, this deserves further discussion. Is there a time limit for me to make a decision? If there is no need for a meeting, as decided by the chairman, the clerk will inform members in writing. Starting from the time when members have read the letter, within 3 working days, members will have to decide whether they would like to call a meeting. In the last term, members were of the view that 2 working days may be a bit short, and is proposed to be extended to 3 days. Is it acceptable to members? That is, a decision is to be made within 3 working days. No problems. The second issue to be dealt with, if members think that there is a need for the meeting to be convened, the previous or existing arrangement is for a meeting to be held within 7 working days. But there may be difficulties to call a meeting within such a short notice. So a proposal was made to extend it to 10 working days instead of 7. But why 10? Why not 14? To allow more time. Why was 10 working days proposed, clerk? There is no information why 10 working days was proposed. The number 10 working days is only the ceiling, the limit. When a decision is made by the chairman, a meeting is to be held within 10 working days. Of course, a meeting can be held before the expiry of the 10 working days. Mr. Ip. Well, I think that 10 working days will be all right, but I am new. Perhaps you should ask the veteran. As the clerk said that towards the end of the legislative term, when members are busy, will 10 working days be sufficient? I think it's a matter of flexibility. If we have 14 working days, it will be easier for a meeting to be held. Now we have 7 members, and if we have 14 working days instead of 10, I think we will have more flexibility. Because you don't necessarily have to wait till 14 days before you hold a meeting. Ms. Emily Lau. Well, I am the most senior one here. I can tell you that it is not necessarily complicated and difficult. We have quite a number of issues to be dealt with. The next one, that is the appointment of a commissioner, is very important. Of course, even after the appointment, we still have to follow up on the cases, although we don't have to carry out the investigation. And I don't know when that will actually be implemented, if that is the case. And it's a complicated issue, and we have to put in time, because it's an investigation not of yourself but of your fellow members. Last time we were criticized that an investigation takes forever, and if you want to speed up, it spells trouble, because you have to spend a lot of time. So whether it's 7 working days or 10, it's not the crux of the problem. It's a matter of flexibility, and I think that wherever possible, as soon as we can go ahead, we should. If we drag our feet, if we delay, and if we want to find a mutually acceptable time, then the matter will be delayed even further. Now 10 working days is proposed. And we will think about whether we need a longer time. Ms. Chen Yunhan. If you ask, I really don't mind. Because currently, whether it's 10 or 15 working days, well, we're busy because we've devoted our time to the council. But as Ms. Emily Lau pointed out, that if the matter drags on, it will be difficult for the member involved. If we can find at the time, well, I do think that it will be difficult. I have to pick and choose. Reluctantly, I have to give up my work related to Kai-Tak. So, do we keep it at 10 working days, or are there any new comments? No? 10 working days then, because that is the proposals made by the last term. Okay. Purpose of the first meeting. Clerk, please. Perhaps I will talk about the purpose of the first meeting together with circumstances under which the CMI ought to proceed to the investigation stage. That is, paragraph 7, 11, and 12. There are two stages when it comes to handling of complaint. First, preliminary consideration stage, and the second stage, investigation stage. When that was set down in 1999, it wasn't because there was a complaint. The opinion at that time was that if preliminary information, before preliminary information is obtained and it's called an investigation, it may have a negative impact on the reputation of the member. That's why at the first stage we call it preliminary consideration stage, where essential information is collected to decide whether an investigation is warranted. There are 5 complaint cases involving 12 members handled by the last CMI, which is quite a high number. The longest case took 18 months and 20 meetings and is still called preliminary consideration stage. So the perception is that it is rather stretched, because after 20 meetings it's still preliminary consideration. Perhaps it's because some paragraphs are not very clear. Say paragraph 11 said that if at the preliminary consideration stage that the member admits all the allegations, then the CMI can prepare for the report, because the may be determined that the complaint is substantiated and report to the LegCo. But when it comes to what amounts to admission to the allegations, it's not very clear. There was a case that the member admit the fact that it was not disclosed to the council, but the member is of the view that he has not breached any code, because there is no need to make such a declaration. So we need to clarify under what circumstances the CMI ought to proceed to the investigation stage, and what matters needed to be dealt with in the preliminary consideration stage.
Members, any comments? The last CMI spent 18 months in the preliminary consideration stage. So I think actually investigation was being carried out, but it was not called investigation, because whenever you call it investigation, it seems very serious. However, in fact, if you need 18 months for preliminary consideration, is quite unacceptable to the public. Now, if a complaint is lodged, then if the CMI is to make preliminary consideration, actually I think some investigations would have already been carried out. So I think this kind of wording is not too exact or clear. So maybe we can make some amendments. We can look at last term's experience. Well, investigation actually doesn't matter. Now the CMI would have to consider a number of factors. Now, for example, if the complaint is anonymous, if it's anonymous, then we will not look into it anyway. And also for the complaint, is it related to our rules? So has the member done something against the rules? So we can look at the facts, and then we can convene meeting to see if these are facts, and if there are no such facts, then we would not go on. So if there's a prima facie case, then we may need to go further, and there will already enter the investigation stage. Chairman, I agree with you. Yes, we can cut it in two parts. First, preliminary consideration, and second, investigation. And then people won't think that we spent dozens of months on preliminary consideration. Now, just now an example was cited. That is the member admitted that he did that. However, he thought that's not a breach. Well, how can that be possible? The rule is that you should not do that kind of thing. So how can he argue that he has not breached the rule? I can't remember what case that was. Were you not there? I was there. However, I'm suffering from senile dementia. How can I remember so many things? Please remind us, Clark. Well, this involves a case related to 3 members. It was alleged that they did not declare their interest because they were executive directors of certain companies. And this was a fact, that is, they didn't disclose their identity in this regard. However, does it mean that it is the same as that stated under paragraph 11, that is, amidst all the allegations, because it's quite ambiguous? It's alleged that they have breached Rule 83 bracket A, but the member under complaint thought he didn't violate Rule 83 bracket A because he thought that was something he didn't have to disclose. Well, Chairman, if that is the case, then of course we have to go into investigation. And if we think that that's a breach, then of course we would start investigation. And why didn't they start the investigation? Of course I can't remember. Maybe the clerk can tell us the story. Well, in the initial preliminary consideration stage, the CMI wrote to the member under complaint for further information, and that process lasted for quite a while. And no member thought that they should enter the investigation stage at any meeting. Now, just now you mentioned paragraph 11. You said that the member under complaint would only have to admit whether the allegation was true. However, the CMI would have to make a decision as well. So if the member under complaint admits the allegation, then the CMI will have to decide whether the complaint is substantiated. Well, what you said just now was really outrageous. Like 20 meetings and 18 months spent on preliminary consideration. I think that's really too much. You should really enter formal investigation, or you should just dismiss it. I think there should be a time limit, and a consensus should be reached. I think the last CMI hope that we can remedy this. Yes, I agree with Mr. Fan Kwok-wai. For the member under complaint, he cannot say that whether he has breached the rule or not. It's for us, the 7 members here, to decide. Now, the clerk told us that, of course, didn't disclose that he was the executive director of those companies. So the CMI members should form a view as to whether he has breached the rule. So if we don't understand what happened, then it's okay because it happened in the past. So the CMI of the full-fledged co hopes that we can do a review now and see if improvements can be made. That is, when should we enter the investigation stage? Now it's easier for us to work because we have last term's experience, because in the past they haven't had such a precedent. Now we have already seen a case like this. So what's our recommendation, or what's the Secretariat's recommendation? We want to do things in a more speedy manner. So what should we do? If members think that there should be amendments, maybe the clerk can draft a proposal, give us a blueprint, then we can have a more detailed discussion next time. So today we have to decide whether we want amendments, right? So we all think that amendments should be made on this point. Okay. Chairman. Now for the preliminary consideration stage meetings, do you want to make amendments to that? Some members suggested that there should be time limit. And also the clerk mentioned another point. That is, under what circumstances should the CMI proceed to the investigation stage? So I would like to seek clarification from members. Do you want the clerk to make amendments to these 2 points? Ms. Emily Lau? Well, for the time limit, I think it's not practical. Well, because we will have to consider what we have to do. Now, if that member admits the allegations, then as to whether the complaint is substantiated, then of course we can decide. But that member has admitted already, but if that member also admits that that's a breach, then that's okay. But if he doesn't think that's a breach, then of course we will have to investigate. But now, even though we are investigating, it's considered as part of the preliminary consideration stage. Now, so if he agrees to both 1 and 2, of course it's okay. So if he only agrees to 1 and not 2, then we will have to start investigation. Does the clerk want to supplement anything? Maybe members can consider this concept. So maybe it's like a criminal proceeding, and you will have to decide whether in the preliminary consideration stage, whether there's prima facie evidence, and if the complaint is substantiated, then you can ask the member under complaint. You can say that, well, somebody is complaining against you concerning these matters, and if he says that it's just an omission on his part, and if he admits that it's his fault, then we do not have to start investigation. But if this cannot be done, well, I think actually this was the original design. That is, if he admits that it's just a minor mistake, then we do not have to proceed to investigation. And if it's a prima facie case and the member under complaint does not agree to the allegation, then we will have to proceed to the investigation stage. Then it will be clearer. Because now for the preliminary consideration stage, it's just about the collection of information, and it does not involve the judgments concerning prima facie case. And under paragraph 7, it's just for the collection of relevant information. It has nothing to do with a prima facie case. Mr. Ip Chiming, clerk, you're confusing me. Okay, now we've received some information concerning a complaint. So we will have to look at the contents of the complaint, whether there are prima facie evidences. Well, the member under complaint will not tell us that, and we will have to make the decision. And if we think the complaint is substantiated, then we will proceed to investigation. But you make it so complicated. Well, what I mean is that if members think that complaint is just frivolous or vexatious, then at the first meeting you can decide not to pursue. And if members think that there may be some facts in the complaint, and that member under complaint might have breached the rules, then the member under complaint should be given a chance. You should tell him that there is such a complaint. Would you admit that? If he admits, then maybe the case can be closed. So the member under complaint would not decide as to whether this is a prima facie case. Yes, I agree with Mr. Yip. Actually, the concept is very simple. There are 3 stages. Now, maybe you should write like this. Now, first, preliminary considerations. So you look at all the complaints, then we will look at the rules of procedures, whether there have been breaches, and then you will start investigation if you think there are breaches. And of course, the member under complaint would have to tell us his story and why does he think that he has not breached anything. So this already involves investigation. In the past, whenever we said investigation, it seemed that it's quite serious. Nowadays, investigation is pretty normal. I'm pleased that now we are having an investigation, and that's done very well. I'm pleased to see that. Well, investigation is being conducted right now. So then after that, we will come to a conclusion. That is whether there is a breach or not. So there are 3 stages, very clear. Let us don't dwell on the word investigation. Don't make it so serious. Can the clerk look at it from this direction? And that would be in line with Mr. Yip's concept. It seems that the clerk focuses a lot on the word investigation. However, according to my past experience, we always held this kind of meeting in camera. And in the electrical report, yes, you can see the word investigation, but it's investigation. That's okay. It's not that serious. Okay, should that be our direction? Can you write it out? Well, in principle, I do not have any comments on this. However, if we agree on certain things, we will have to consult members. Well, some members may be very sensitive. They will think that if they are investigated by the electrical, they would be very unhappy. So I think we have to explain to them very clearly these are just stages. I hope that members can accept our proposed amendments. I think members may mind this, that is, whenever we say that's an investigation, then the public would know. But if we work in accordance with our rules of procedures, I don't think this would be a problem. Chairman, you think, well, you should know that, well, there are things that should not happen, but they always happen. But if there are rules, then we should adhere to these rules.
對呢一點上
So, now we move on to first meeting. What is the first meeting? I think that's resolved. And then, paragraph 9. Among the complaints received by the last CMI, the general situation is that a complainant reads from the press that a member has breached certain rules, and a complaint is made to the CMI. Some complainants will furnish detailed information, whereas some others will only refer to the press article. That the CMI did not have enough time to discuss as to what may be contained in the complaint and how much information should the CMI collect. There are views that the CMI has no duty to complete the complaint for the complainant. So if there is missing information, some people think that they should not be pursued, whereas some people think that since it is reviewed by the press, if it is true, it is quite serious. The complainant may not know how to furnish all the necessary information for the matter to be taken up. If it is widely reported by the media, are we going to start handling it as a result? What's your view, Ms. Emily Lau? You're a member of the last CMI. Chairman, if it is widely covered by the media, if we do not pursue it because there is no complaint referred to us, it will be difficult for us to explain to the public. And if it is too vague to take it up, then there is no way we can start an investigation. But if there is a detailed information reviewed by the press report with dates and things like that, then it will be difficult for us not to look into it. The current practice is that we cannot trigger an investigation simply is reported by the press or if it is an anonymous complaint. We need to have a complainant, and the complainant should make allegations. Then the CMI will look into whether the allegations are substantiated. And if the CMI also deals with what allegations they are, there may be a conflict. SG. I'd like to clarify one point. We are not asking members to discuss about whether to start an investigation because of a press report. What we are dealing with is that there is a complainant, but the information furnished by the complainant does not give us a complete picture. The information may be disclosed by the media, but the complainant does not furnish us with that information. And do we not consider the missing information simply because it's not furnished by the complainant? Well, if it is something to do with widely reported by the media, I think we will have a lot of work to do because everything will be widely reported by the media. Because there are party politics and the different parties attack one another. But what kind of complainants are we talking about? Well, if it is widely reported, I think it means that someone has shown some interest. Well, if there is no complainant, even after an extensive media coverage, well, if it is not furnished by the complainant, can we use it as a part of the information under consideration? I think that is the point raised by the last CMI. I think that's my understanding of the issue. We're here to discuss this point. There was no conclusion drawn by the last CMI. Mr. Franklin Yick. It says here whether to consider in the first meeting information not furnished by the complainant. I think we'll have to look at the chronology. A complainant might have made a complaint against a certain member, and then there are further investigative report. Will we consider such information? I think we should consider all relevant information. We'll decide whether to follow it up. And in the first meeting, we can decide whether to consider such information. But if it is reviewed, there is no reason for us not to consider it. I wasn't a member of the last CMI. And I think Miss Emily Lau will be the one in a position to say something. Well, it was pointed out that we don't have the duty to perfect or improve the complaint. There may be a lot of missing information furnished by the complainant, but there are other information reported by the media. And if you piece them all together, it will be a perfect picture. Some people may think that we should not take into consideration the missing information. And I think, well, there was a heated debate on this point. The reports themselves may not be accurate, but there is a lot of information. We cannot have a blinkered vision. We cannot simply ignore the information available in the realm of the media. Mr. Jeffrey Lam. This is a chance for us to review whether there is a need to improve the system, and people talk about party politics is yet to happen. And if it does happen, is our current system and our rules and procedures adequate and appropriate? If we do have party politics, well, we don't know whether we will have party politics, but when it comes to a complaint, if we act as a detective to look at what has been reported by the media and then piece them all together to form a picture, and then decide based on this picture pieced together, then it depends on what picture we piece together. We will have to decide what information is correct and what not. There may be problems. Do we have to do that? We need to consider it. Ms. Chen Yun Han. Well, it occurs. It reminds me of the SARS Select Committee on the Select Committee on the short piles. We read a lot of things. We could ask Chen Fengfuzhen and relevant officials. Mrs. Margaret Chan and the relevant officials. If you say that there is this incident and the complainant did not read it, but there is abundant information reviewed by the media, I need to ask, how will the Select Committee handle it? We will definitely take them into consideration, because if they may give us some inkling of what happened. If we have a different standard than the one adopted by the Select Committee, we may be queried. In relation to CMI and Select Committee, there is a common area in that you exercise your power based on the terms of reference. Say, for example, the Select Committee on foreign workers or the airport. The remit of the work is set down by the terms of reference. But the CMI's power is set down by the terms of reference referred to in Rule 73(1)(c). And when it comes to information to be considered in the first meeting that is not furnished by the complainant, well, according to the rule, the responsibility of the committee is to look into or investigate into the complaint. And it is mentioned, well, the problem is one of it being alleged as a fishing expedition, as mentioned in the paper. But we're talking about information reviewed by the media but not furnished by the complainant, and in relation to the first meeting. In that meeting, we'll have to decide whether to start an investigation. Whether the facts amount to a breach. If we think that it warrants an investigation, my understanding is that press reports will be taken into consideration as part of the information available. Am I right to understand it this way? Legal advisor. So it will take us back to 73(1)(c). Just now the clerk mentioned, say for example, disciplinary hearing of professional bodies or some indictable offense in the it's called the first instance, the preliminary committal hearings. Well, when there is a complaint, the CMI will have to consider the complaint, and it says that if it thinks fit after consideration, the committee shall investigate such complaint. If it thinks fit after consideration, if it thinks fit may be an abstract concept. It also shows how the executive, the legislature views such procedures. Is it appropriate? If there is prima facie case, and if an investigation is not triggered, then people will cast doubt on the reason why you don't do so. And when it comes to circumstances outside, whether there is a prima facie case, I think it is for the committee to consider. The conclusion of the last CMI was to look at it on a case-by-case basis. That is the last line of paragraph 12. That is, the committee should decide on a case-by-case basis and will be responsible for their own judgment and be held accountable for its decision. So, and there are concerns that the word investigation may have a negative connotation. So, in the design of the 73(1)(c), the word "if it thinks fit after consideration" is put in. Yes, I understand. But the current discussion is whether we should take into consideration such information in the first meeting. You have to decide now if you think that such information should be considered. Well, then I will ask members what they think. I think the current proposal is not to consider them. But it says that it's done is to make its own judgment on each case. If that is the case, there is no further discussion required. A member pointed out a matter of principle, whether the committee has the duty to improve the complaint. In the last CMI, a member said that this has to be handled very carefully, because if we perform this duty, then from the concept of natural justice, there will be a conflict, because there may be the perception that we play the role of a complainant, and that is not clear and is not desirable. But it's sometimes difficult to draw the line. And that's why we need to consider it in the case.
Ms. Chen Yihan? Yes, my view is like this. Now, if we investigate, now it says here that the CMI have to make its own judgment on each case while being held accountable for its decision. So it seems that we have a very heavy responsibility. Now, the press may report on a lot of things, but that's not contained in the complaints. Then if it's up to me, then I would say that, well, let's not look at this information. So it's just like a blindfolded horse. We would not look at the other things. We would just focus on the complaint itself. So it's like 73C. Maybe the legal advisor can help us to draw a line. I know it's very difficult to draw that line, because there will be a lot of reports in the media. Now we already have party politics. So whenever there's elections, we will see party politics. So I would like to ask the legal advisor to help us. Now, if it's for me to make a judgment, is very difficult. But if we just focus on the complaint itself, there are also a lot of problems. Mr. Ip, just now the legal advisor made it very clear already. That is, we should look at the complainant's complaints and whether the content is substantiated. As for what's reported in the press, there are also rumors. Maybe they cannot be proved. So if CMI does not think that we should pursue, and if this is widely reported in the media, then the complainant will come back to us. He will lodge another complaint. He will say that, how come you are ignoring the press reports? So actually, I'm inclined towards the thinking of the legal advisor. Well, for party politics, of course, it does exist. We just do not have a party in ruling. And also in other countries, they also have a mechanism to look into the parliamentary members' breaches. Now, Chairman, for the first meeting, I'm referring to paragraph 9, and if there is no additional information in the complaints and is a difference, but if it's widely reported and if the Secretariat collect all those information and give the information to us for consideration, I think that can be considered. But here it also talks about fishing expedition. And what is meant by fishing expedition? Now, if you show us all the news concerning this complaint, is it a fishing expedition? Well, you can say that, well, it's reported in the newspapers, it's on the front page every day, and we should still ignore it. And we think the complaint is not substantiated, and that would really be difficult for us to explain. So we should look at the press reports, and maybe those reports can help us understand the complaints more. So that would just be used as reference materials, right? Yes, I wonder if members can accept this. You can't just say that I would look at the rules of procedure and the complaint letter only. Mr. Jeffrey Lam? Well, Chairman, this is really difficult. If you just look at the complaint letter and then decide on whether we should pursue the complaint, yet this complaint is widely reported in the press. So how can we just focus on that piece of paper which contains the complaint? I think we really have to make our judgments on each case. Now we do have party politics. We just do not have a comprehensive party politics because our CE cannot belong to a political party. I don't think we have to decide on a system today. Well, each case is different. Each report is different, so I think we should be more flexible. Chairman, maybe you should make a wise decision. I think we need not change this. However, I can accept that if there are relevant media reports, then at the first meeting, we can view these reports as information so that members can make reference to them. Because at the end of the day, the CMI will have to decide whether the complaint should be pursued. But the press reports cannot be incorporated into the complaint because we have to look at the relevant rules. Chairman, sorry, I had another meeting. That's why I had to walk in and out of this room. Well, if we look at other bodies, for example, the Bar Association, the Medical Council, the Law Society, they have their own frameworks. As for the width and depth of the framework, it depends on each and every case. However, for our framework, is it too broad now? If a member has a problem, then a lot of newspapers will report on that. If we look at all these allegations in newspaper reports, and if that member is asked to answer to all these reports, then it would be impossible. No, we are not talking about that. We're talking about the first meeting, and we have a complaint. And in the course of that, there's a lot of press reports. Yes, Chairman, I understand. Now, if you are saying that if there are reports in newspapers, then do we have to incorporate those reports into our investigation? Well, that would be very chaotic, and also the focus will be blurred because the complainant would be complaining about a certain thing, and then about that there may be a lot of reports, and if those reports are to be incorporated, yes, that may be understandable. However, for that particular allegation, if there are reports surrounding it, and these reports are not directly relevant to complaints, and if we are to investigate into those reports, then the focus will be blurred, and this will cause a lot of problems. If we look at other public bodies and associations, they must be quite tunnel visioned. That is, they have to focus on the complaint itself. It doesn't mean that they have to ignore all the other information. However, they have to be pretty focused on the complaint itself. That will be clearer. Well, I think your view is similar to that of Ms. Samlina. We have to focus on the complaint itself, and then the other information can be there for reference, and members can then make their own judgments. Secretary General. We are talking about paragraph 9, as the chairman mentioned just now. Now, actually, we're talking about the first meeting. And it says additional information here. As the chairman mentioned just now, maybe a lot of reports in the press, and the secretariat can collect this kind of information for members' reference. Yes, I understand that. However, if there are other information, for example, if CMI asks the secretariat to look for certain information, and I hope members can understand that this is just the first meeting. This has not entered the investigation stage yet. So we will just look at the information we have in hand, because this is the first information. Yes, that's how I understand it as well. We are not asking the secretariat to do investigation. We are just looking at the information that's available to us at that point. Okay. Then at the first meeting, if CMI decided not to pursue the complaints, then should the member under complaints be informed? Well, this morning, at the security panel meeting, the commissioner for ICAC was here, and he said that if a complaint is not substantiated, the person under complaint should be informed. Well, because for that kind of complaint, it's public. But for our cases, well, maybe it's not. Maybe the public does not know about it. But we should inform the member anyway. That is, we should tell. We are duty bound to tell the member that that complaint will not be pursued. What do members think about this? Well, can the clerk give us some information? How come in the last term it's decided not to inform the member under complaint? Please turn on the clerk's microphone. Well, some members said that you should not tell me. You don't have to tell me. I do not have the interest to know. Some members said that, well, as long as the complaint is not substantiated, you do not have to tell me. So the different members had different views. Well, I agree that the member under complaint should be informed. Legal advisor? Now, if a complaint is not substantiated, that means there is no complaint. And we may see many cases like this. And the members under complaint may be affected. So if he wants to know and then we cannot tell him, there may be a problem. I don't think it serves any purpose by not telling him. Maybe we should tell the member that there was a complaint against him. I think we can have an expedient measure. Well, now we are in a new term. We don't know which member will be the subject of complaint. Maybe we can ask members. They can have a choice. That is, well, you can choose whenever there's a complaint, you should be informed afterwards, and you can choose not to be informed. Well, from CMI's point of view, I think we can inform the relevant member, but some members just don't want to know. They think this is quite useless. Can we do this? What I mean is that we can tell all our members. That is, you can have a choice in the future. If CMI receives a complaint and if the complaint is not substantiated, then you can be informed. But if you think that you do not want to be informed, you can also choose that then we will not inform you.
可以解決嘅方法。
That may be a way to deal with it. But if the complaint is not substantiated, it will not be made public. It's only that the person involved will be informed, and you will not disclose the identity of the complainant. You just inform the member that there was a complaint against him or her, and it's not substantiated. And if a member indicates that he or she does not want to know about it, then we'll leave it at that. Maybe proceed this way. I think it acceptable to all members. We've dealt with paragraph 10. So we've gone through the whole paper. Yes. If that is the case, we will go to agenda item number 3. Proposal of appointing a commissioner to handle complaints against members. This is also a matter discussed by the last CMI. It's paper number CMI 27. Clark, would you please take us through it? Yes, I'll do it briefly. This is to follow up on a proposal of the last CMI. That is to appoint an independent person as a commissioner to investigate complaints against members. Paragraph 8. The CMI considered approaches of overseas jurisdictions for handling complaints against members, in particular UK and Canada. They are of the view that the UK mechanism is most related or relevant to the matter under consideration. Under the UK mechanism, the Commissioner is responsible for receiving and investigating complaints about members who are allegedly in breach of the Code of Conduct for members of the Parliament. And when it comes to the drawing up of a Code of Conduct for LegCo of members and also the handling of complaints, on 2 occasions it's been debated, and they have been negatived. The CMI sought the advice of Sir Malcolm Jack, a retired clerk of the UK House of Commons. Sir Malcolm is of the view that without such a code, it will make the job of the Commissioner very difficult. And if there is a Commissioner, the public will have the expectation that the Commissioner will deal with matters related to a wide scope of the member. The CMI's view is that a first step has to be taken by appointing an independent person as a commissioner to receive and investigate complaints against members within the remit of the CMI, in order to avoid members investigating into fellow members, and this may expedite the process. The UK mechanism is that the Commissioner will receive complaints and decide whether to follow up on the complaint. And the Commissioner will have to report to our committee. So still, the committee will have to convene a meeting and decide whether to accept the report and decide on whether a sanction is in order. The Commissioner is only responsible for the investigation. If a Commissioner is to be appointed, the Commissioner should command respect from all parties, and it should possess a certain level of qualification. In the annex, you will find the opinion of members. About 40% of members think this proposal should be followed up, whereas some members disagree with the proposal, and some members think that the matter should be considered by the next term, i.e. this term. The Commissioner has no power to call witnesses under the UK mechanism, so they need the cooperation of members of the Parliament. Otherwise, the Commissioner will have to go back to the committee to summon certain people and to demand certain information. Ms. Emily Lau. I strongly support the idea of the appointment of a commissioner because we can avoid the allegation by the criticism of the public that we investigate into our fellow members. Of course, in the end, the matter will come back to us. If the committee in the end say that we do not agree with the commissioner, then we'll have to support it with grounds. It's not the case that we're lazy. We have a lot of work to do in the council. If there is a complaint against a member, I've read from the press that we have a number of them coming, unless it's wrongly reported by the press. In Annex 3, you see, the Democratic Party agrees with this proposal. Annex 6, we think that the Commissioner should be appointed upon the passing of a motion in the Council by 4/5 majority of the members present, to show that he or she gets the support of different parties. If you can find a credible, an authoritative and independent member to be the Commissioner, then you will get the 4/5 support. Otherwise, you will not get 4/5 support. We hope to put in place such a threshold that when a nomination is made, it has to be endorsed by the council members. Mr. Dennis Kwok. There are 500 to 600 MPs, members of the Parliament, in the UK system, so there may be a lot more investigations involved, and it's based on this reason that they need to have an independent commissioner, but we have a lot less members than the UK Parliament. I agree with what Ms. Emily Lau said. It will be a proper procedure to have the Commissioner taking care of the investigation to avoid the criticism that we're investigating into our fellow members. But do we have the need? We may appoint a Commissioner, say for 3 years, and there may not be any investigation done. If you appoint a full-time Commissioner, have you thought about the actual operation? I've read something in the 4th term. They say that if a commissioner is to be appointed, it will have 2 major duties. First, to investigate into complaints related to the registration and declaration of members' interests. The second part is claims for reimbursement of operating expenses and applications for advance of operating funds. We don't have code of conduct for members, so there won't be any guidelines for the commissioner to follow. And without such a code, well, it seems that, correct me if I'm wrong, the accounting department monitors expenditures incurred by or claimed by members. Now, that is the case in past terms. Is it still the case, SG? The accounting section or the accounting team under the Secretariat will have dedicated staff members to process applications for claims for reimbursement of operating expenses. We also have staff members dealing with registration of members' interests. We do have staff members dealing with that as part of our routine work. Mr. Jeffrey Lam. There's always been allegations that the administration is building an unnecessary structure, and it seems that we're doing the same thing here. Is there a need? You have to carefully think it through. Mr. Kwok touched on this. Is this commissioner going to be full-time? Last CMI mentioned about a part-time commissioner. If it's part-time, then I am concerned. What if his other work is very heavy? Then he may not be able to deal with our matters swiftly and efficiently. Perhaps we can cross the bridge when we come to it, when decide when we indeed cannot cope with the amount of complaints. Mr. Frankie Yik. Yes, I agree that there are a lot more MPs in the UK system compared to ours. So far we only have one complaint. I have an idea. If we are involved, then we will actually think about, consider the case, and will be fairer for the members. Say, for example, there is a case in court, and then there is a jury, and if in the end the judge will brief the jury, well, I think it is unnecessary to have a commissioner. Mr. Lam, what I'm afraid is that if we have a commissioner, someone may seize the opportunity to put up a show, to be very high profile when approaching the commissioner to lodge a complaint. As I've said, I don't think that this is the time to decide about an appointment of a commissioner. When it comes to investigation into our fellow members, I don't think the appointment of a commissioner will be able to dispel the concern that we're investigating into one of our own, because the commissioner may be responsible for the investigation, and in the end it will come back to the committee about sanction or how to handle it. So we still have a role to play. If you say that appointing an outsider will dispel the concern about investigating into one of your own, I have reservation. Basically, we accept that the Secretariat is independent. They furnish us with information, and they are responsible for collating the information.
So, for investigating our fellow members, I don't think the appointment of a commissioner can solve the problem. Mr. Lau, I hope that an independent commissioner can handle these complaints, and I don't agree with you. And of course, legislative councillors should not be spending 18 months on the investigative work of their fellow members. So I think we should consult the members because, in particular for the young legislators, they should be given a chance to express their views. Yes, I agree with Ms. Samuel Lau because this is a very important issue. And I think we should have an in-depth discussion with our fellow members. And I also expressed my views just now. Okay, any other comments? Mr. Fett? No? If that is the case, then I will summarize members' views. Members have expressed their views. And shall we accept Ms. Emily Lau's comment? Now, this is a new term, so we should allow members of the new term to make this decision. That is, they should fill in a questionnaire, and then they will tell us what they think about appointing a commissioner to handle complaints against members. And then we will look at their comments, and at the next meeting, we will make a decision. Okay? We will do that as soon as possible. I think we should make it clear. That is, we should let members know that we have different views, and for the appointment of a commissioner, the Democratic Party, in the Democratic Party, actually 80% of its members. What, 18%? Oh, you mean 4/5? That is, at a council meeting, there should, at a council meeting, 4/5 of the members would have to agree. So all these would have to be highlighted so that members would know. Yes, if we decide to appoint a commissioner, then we will have to do this, right? But the clerk put it here at the second line. If you look at Appendix 3, well, clerk, I'm sorry, yes, you say agree here. But all these information should be given to our fellow members. Okay, the members of last term have expressed their views, so we should also let the existing members know about these views. All right? So this is our decision, and we will do it as soon as possible. We do not want to drag our feet. We want to handle this as soon as possible. Okay, let's conclude the discussion of this AOB. Do we have any other business? No? So the date of the next meeting will be decided on, and we will inform members later. Thank you for attending the meeting.
對唔住，佢就